This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. In any investigation or trial, attention is often focused on the answers, what was proven, what was established, and what conclusions were reached. But equally important is another aspect that receives far less attention: the questions that were never asked. These unasked questions are not always the result of oversight. In many cases, they are a direct consequence of how legal systems are structured. Courts are not designed to explore every possible angle or curiosity. Instead, they operate within a framework that prioritizes specific, relevant, and legally actionable questions. This creates a boundary. Only questions that directly relate to the charges and can be supported by admissible evidence are included in the process. Everything else, no matter how interesting or potentially important, may remain outside the courtroom. This is the first key principle. A trial is not an open-ended inquiry. It is a focused examination of defined issues. Because of this, many potential questions are never raised. Some questions may fall outside the scope of the charges. If a line of inquiry does not contribute to proving or disproving a specific legal element, it is unlikely to be pursued in court. Others may lack supporting evidence. Even if a question is relevant, it cannot be meaningfully addressed without material that meets legal standards. Without that support, raising the question may have little value within the trial process. There are also procedural constraints. Attorneys must work within rules that govern how questions can be asked, when they can be introduced, and what they must be based on. These rules are designed to ensure fairness, but they also limit the range of inquiry. Another important factor is strategy. Both prosecution and defense must decide which questions to ask and which to leave aside. Asking too many questions, especially those that are unclear or weakly supported, can dilute a case and create confusion. As a result, the questioning process is highly selective. It focuses on what is necessary to build or challenge a legal argument, rather than exploring every possible detail. This selective approach shapes the entire trial. What is asked becomes part of the record. What is not asked remains outside it. Understanding this distinction is essential. Because when a case concludes, the answers that are available are only as complete as the questions that were included in the process. In a courtroom, not every question that could be asked is allowed to be asked. The determining factor is legal relevance, a standard that defines whether a question contributes directly to the issues being decided in the case. Relevance is not a general concept. It is specifically tied to the charges and legal elements under examination. For a question to be permitted, it must help establish or challenge a fact that is necessary for proving those elements. If it does not, it is excluded. This creates a clear filter. Questions that may seem important in a broader sense, such as those exploring background, associations, or unrelated events, can be ruled irrelevant if they do not directly impact the legal claims being tested. This is why many potential lines of inquiry never reach the courtroom. They fall outside the defined scope of the case. Another important aspect is judicial control. Judges have the authority to decide whether a question is appropriate. If a question is deemed irrelevant, misleading, or unnecessarily repetitive, it can be blocked before it is answered. This ensures focus. Trials are designed to remain centered on provable and legally significant issues, rather than expanding into areas that do not affect the outcome. There is also the matter of efficiency. Allowing every possible question would make trials unmanageable. By limiting inquiry to relevant material, the court maintains a process that is both structured and practical. This leads to selective questioning. Attorneys must carefully choose which questions to ask, knowing that each one must serve a clear legal purpose. Questions that do not meet this standard are often avoided altogether. Another factor is risk. A question that appears relevant may still be avoided if it introduces uncertainty or opens the door to unfavorable responses. Legal teams must consider not only whether a question can be asked, but whether it should be asked. This further narrows the field. As a result, the questioning process becomes a balance between legal permission and strategic choice. It is important to understand that relevance is not about curiosity. It is about necessity within the legal framework. If a question does not contribute to proving or disproving a charge, it has no place in the trial. This explains why some questions, despite being widely discussed outside the courtroom, are never raised within it. They do not meet the standard required to become part of the legal record. Understanding relevance clarifies a key point. A trial answers only the questions that are legally permitted and necessary. All other questions remain unasked, not because they are impossible, but because they are outside the defined boundaries of the case. Even when a question appears relevant, it may still never be asked in court due to rules of evidence and admissibility. These rules do not only control what evidence can be presented, they also shape which questions are allowed to be pursued. A question in court must be grounded in admissible evidence. Attorneys cannot ask questions that assume facts not in evidence or that rely on material the court has excluded. This immediately limits the scope of inquiry. If the underlying evidence is not permitted, the question itself cannot proceed. This creates a direct link between evidence and questioning. For example, if a document is ruled inadmissible, any question based on its contents may also be blocked. The court ensures that questioning does not indirectly introduce material that has already been excluded. Another major restriction involves hearsay rules. As discussed earlier, hearsay refers to statements made outside of court that are offered as proof. Since hearsay is often inadmissible, questions that depend on such statements may also be disallowed. This prevents second-hand information from entering the record through questioning. There is also the issue of speculation. Courts do not allow questions that ask a witness to guess, assume, or speculate about events beyond their direct knowledge. Questions must be based on what can be personally observed or reliably established. This significantly narrows what can be asked. Even if a line of questioning seems logical, it may be blocked if it requires the witness to go beyond verifiable facts. Another limitation is foundation. Before certain questions can be asked, attorneys must establish a proper basis, showing that the witness has the knowledge or authority to answer. Without this foundation, the question can be challenged and excluded. This adds another layer of control. Questions must not only be relevant, they must also be properly supported by the structure of the evidence. There is also the concept of prejudice and confusion. If a question is likely to mislead the jury, introduce bias, or shift attention away from the central issues, it may be disallowed. Courts aim to ensure that questioning remains clear and focused. This reinforces a key principle. Not all meaningful questions are legally appropriate. The courtroom is not a place for open-ended exploration. It is a controlled environment where inquiry must follow strict rules. As a result, some questions are never asked because they cannot be supported, structured, or justified within the evidentiary framework. They may exist as possibilities, but they do not become part of the legal process. Understanding this helps explain why the absence of certain questions is not accidental. It is a direct outcome of how evidence is regulated. Even when a question is legally allowed and supported by evidence, it may still remain unasked. One of the most influential factors in this outcome is legal strategy. In a trial, every question has a purpose. Attorneys do not ask questions simply to gather information. They ask them to support a narrative, challenge an argument, or reinforce a specific point. If a question does not clearly serve one of these goals, it may be set aside. This creates a deliberate filtering process. Legal teams must constantly decide not only what they can ask, but what they should ask. This distinction is critical, and it often determines which questions are never heard in court. One major consideration is risk. A question can introduce uncertainty. It may lead to an unexpected answer, provide the opposing side with new opportunities, or weaken an existing argument. Even a relevant and admissible question can be avoided if it carries too much risk. This is especially important during cross-examination. Attorneys typically avoid asking questions unless they already have a strong expectation of the answer. Unpredictable responses can shift the direction of a case, sometimes in ways that are difficult to control. Another factor is focus. Trials are structured to present clear and persuasive arguments. Asking too many questions, or exploring too many directions, can dilute that clarity. Legal teams often limit questioning to what is essential, leaving other areas unexplored. There is also the issue of narrative control. Each side aims to present a coherent version of events. Questions that do not align with that narrative, even if they are relevant, may be avoided to maintain consistency. This means that some questions are not excluded by the court, they are intentionally omitted by choice. Time constraints also play a role. Trials operate within limited timeframes. Attorneys must prioritize the most important lines of questioning, which means that less critical areas may never be addressed. Another consideration is cumulative impact. If a point has already been established through strong evidence or testimony, additional questions on the same topic may be unnecessary. Rather than repeating or overcomplicating the issue, attorneys move on. All of these factors contribute to a selective process. Questions are chosen carefully, based on their strategic value, not just their relevance or possibility. This leads to an important conclusion. Some questions remain unasked not because they are forbidden, but because they are strategically unnecessary or potentially harmful. Understanding this adds another layer to the trial process. It shows that what is heard in court is not only shaped by rules, but also by deliberate decisions made by those presenting the case. Even when a question is relevant, admissible, and strategically sound, it may still remain unasked, or unanswered, due to limitations related to witnesses themselves. The legal process depends heavily on human testimony, and that introduces factors that cannot be fully controlled. The first limitation is memory. Witnesses are asked to recall events that may have occurred months or even years earlier. Over time, details can fade, timelines can blur, and certain aspects may no longer be clearly remembered. Attorneys must consider this carefully. Asking highly specific or detailed questions may not produce reliable answers if the witness cannot recall the information with confidence. In some cases, it may be more effective not to ask at all. Another factor is certainty. Courts rely on testimony that is clear and consistent. If a witness is unsure, hesitant, or inconsistent, their answers may carry less weight. Questions that are likely to produce uncertain responses may be avoided for this reason. There is also the issue of scope of knowledge. A witness can only answer questions based on what they personally saw, heard, or experienced. They cannot speak to events outside their direct knowledge. Questions that go beyond this boundary are not only ineffective, they may be disallowed. This naturally limits the range of inquiry. Even if a question seems important, it cannot be pursued if no available witness has the ability to answer it directly. Another important consideration is credibility. Attorneys must protect the reliability of their witnesses. Asking questions that expose gaps in memory or inconsistencies can weaken credibility. As a result, some lines of questioning are avoided to maintain a witness's overall strength. There are also emotional and psychological factors. Testifying in court can be stressful. Witnesses may experience pressure, discomfort, or difficulty discussing certain topics. This can affect how questions are asked, or whether they are asked at all. In sensitive cases, courts may also impose additional protections. These can limit how questioning is conducted, especially when it involves vulnerable individuals. This further shapes what can be explored during testimony. Another limitation is communication clarity. Questions must be understood by the witness. Complex or unclear questions may lead to confusion or misinterpretation. Attorneys often simplify their approach, which can result in narrower lines of inquiry. All of these factors contribute to a key reality. The effectiveness of a question depends not only on legal rules, but on the ability of a witness to provide a meaningful answer. If that ability is limited, the question itself may never be asked. This highlights the human dimension of the legal process. Trials are not conducted in abstract terms. They rely on individuals, each with their own limitations and constraints. As a result, some questions remain unasked because they cannot be reliably answered within the human context of testimony. Even in complex and high-profile cases, a trial does not have unlimited time. One of the most practical, and often overlooked, reasons some questions remain unasked is the presence of strict time constraints and structured courtroom procedures. A trial operates within a defined schedule. Court sessions are limited by daily time blocks, procedural phases, and overall case management decisions. Judges play a central role in ensuring that proceedings move forward efficiently, which directly affects how much questioning can take place. This creates prioritization. Attorneys must decide which questions are essential and which can be left aside. Even relevant and admissible questions may never be asked simply because there is not enough time to explore every possible angle. Time is not just limited, it is strategically allocated. Each side is given opportunities to present its case, examine witnesses, and respond to arguments. Within these limits, legal teams must focus on the most impactful lines of inquiry. This leads to selective depth. Certain topics are explored in detail, while others are addressed briefly or not at all. The goal is to maintain a clear and efficient presentation, rather than an exhaustive one. Another structural factor is the order of proceedings. Trials follow a sequence: opening statements, direct examination, cross-examination, and closing arguments. Each phase has its own rules and constraints, which influence when and how questions can be asked. If a question does not fit within the structure of a particular phase, it may never be raised. There is also the issue of judicial intervention. Judges can limit questioning if it becomes repetitive, irrelevant, or time-consuming. This ensures that the trial remains focused, but it also reduces the opportunity to pursue extended lines of inquiry. In some cases, attorneys may be instructed to move on. When this happens, additional questions, no matter how relevant, may be left unasked due to the need to maintain the pace of the trial. Another consideration is jury attention. Long or overly detailed questioning can lead to confusion or fatigue. Legal teams often streamline their approach to keep the jury engaged and focused on key points. This further narrows the range of inquiry. Even when more questions could be asked, they may be omitted to preserve clarity and effectiveness. There is also the practical reality of case management. Courts must handle multiple cases, and extended trials place demands on resources. Efficient proceedings are necessary, which reinforces the need for focused questioning. All of these factors combine to create a structured environment where not every question can be explored. This is not a flaw, it is a function of how the legal system operates. A trial is designed to reach conclusions within a reasonable timeframe, using the most relevant and impactful information available. As a result, some questions remain unasked because they fall outside what can be realistically addressed within the limits of time and structure. Beyond relevance, strategy, and time constraints, there are certain areas that are legally off limits in a courtroom. These are governed by rules of privilege and protected information, which can prevent entire categories of questions from ever being asked. Legal privilege is a fundamental principle. It protects specific types of communication from being disclosed in court, even if those communications are relevant to a case. The purpose is to preserve essential relationships and rights within the legal system. One of the most well-known examples is attorney-client privilege. This rule ensures that communication between a client and their legal counsel remains confidential. Because of this, attorneys cannot be forced to reveal these discussions, and opposing counsel cannot ask questions that would expose them. This creates a firm boundary. No matter how relevant a question might seem, if it touches on privileged communication, it is not allowed. There are other forms of privilege as well. These can include protections related to certain professional relationships or specific types of sensitive information. Each of these categories defines areas that are legally shielded from inquiry. Another important concept is self-incrimination. Individuals have the right to avoid answering questions that could expose them to legal risk. This means that even if a question is permitted, a witness may decline to answer under legal protection. This can leave gaps in the record. Questions may be asked but remain effectively unanswered, or they may be avoided altogether if it is clear that the response cannot be compelled. There is also the issue of confidential or classified information. In some cases, certain material cannot be disclosed due to legal restrictions beyond the courtroom itself. This may involve privacy protections, ongoing investigations, or other legal safeguards. When such information is involved, questioning is limited or entirely restricted. Another factor is judicial enforcement. Judges ensure that privileged and protected areas are respected during proceedings. If a question crosses into a restricted domain, it can be immediately stopped. This reinforces the boundaries of inquiry. Attorneys must be aware of these limits and structure their questioning accordingly. Attempting to pursue restricted topics can result in objections and rulings that prevent further exploration. The result is a category of questions that are never asked, not because they are irrelevant, but because they are legally prohibited. These questions exist outside the reach of the trial process. Understanding privilege and protection highlights an important aspect of the legal system. Not all information can be examined in open court. Some areas are intentionally shielded to preserve rights, confidentiality, and legal integrity. As a result, certain questions remain permanently outside the scope of courtroom inquiry. Not all limits on questioning come from inside the courtroom. In many cases, external factors, including investigative boundaries, public attention, and information access, also shape which questions are pursued and which remain unasked. The first of these factors is investigative limitation. Before a case even reaches trial, investigators must decide which leads to follow and which to leave aside. These decisions are influenced by available resources, time, and the likelihood of obtaining verifiable evidence. If a line of inquiry is not fully developed during the investigation, it may never reach the stage where it can be asked in court. This creates a chain effect. Unexplored or incomplete leads at the investigative level become unasked questions at the trial level. Another factor is availability of information. Not all data is accessible. Some records may be lost, incomplete, or legally restricted. Without access to reliable information, certain questions cannot be properly formed or supported. This limits the scope of inquiry from the outset. There is also the role of public attention in media coverage. High-profile cases often generate widespread discussion. Media outlets may highlight certain aspects of a case while giving less attention to others. This can influence which questions are emphasized in public discourse. However, the courtroom operates differently. Legal teams are guided by evidence and legal standards, not by public curiosity. As a result, questions that are widely discussed outside the courtroom may still remain unasked within it. This creates a contrast between public narrative and legal process. Another important factor is institutional focus. Investigative bodies may prioritize specific objectives, such as addressing the most immediate or provable issues. This can leave other areas less explored, even if they are connected to the broader context. These priorities shape the information that ultimately reaches the courtroom. There is also the issue of information timing. In some cases, relevant material may emerge after key stages of the investigation or trial have already passed. When this happens, the opportunity to ask certain questions may no longer exist within that proceeding. This highlights a key limitation. The legal process operates within a defined timeframe, while information can emerge at any point. Finally, there is the matter of access and control. Not all participants in a case have equal access to information. Differences in access can affect which questions are possible, as well as how thoroughly certain areas can be explored. All of these external factors contribute to a broader reality. The questions asked in court are shaped not only by legal rules, but also by what was available, pursued, and prioritized before the trial began. This means that some questions remain unasked not because they lack importance, but because the conditions required to ask them were never fully met. Understanding these influences helps explain why gaps can exist between what is discussed publicly and what is examined legally. When certain questions are never asked, their absence does not go unnoticed. Instead, it becomes part of how a case is interpreted, discussed, and understood over time. The silence around unasked questions can shape perception just as much as the answers that are provided. At the core of this issue is incomplete visibility. A trial presents a structured set of questions and answers, but it does not represent every possible line of inquiry. As a result, observers are left with a record that is accurate yet limited. This limitation creates space for interpretation. When people recognize that certain questions were not explored, they may attempt to fill those gaps using external information, analysis, or personal assumptions. This can lead to different conclusions based on the same case. Another important factor is contrast between expectation and reality. In complex or high-profile cases, there is often an expectation that every detail will be examined. When that does not happen, the absence of certain questions can appear significant, even if it is the result of normal legal constraints. This can influence perception in different ways. Some may view unasked questions as evidence of limitation within the legal process. Others may see them as areas that require further investigation outside the courtroom. Both perspectives highlight the same reality. The trial record is not exhaustive. There is also the role of narrative formation. Stories about a case are often built around what is known. However, what is not known, or not addressed, can become just as influential. Unasked questions can shape narratives by defining what remains uncertain. This uncertainty can persist over time. Even after a case concludes, unanswered or unasked questions may continue to be discussed, analyzed, and revisited. They become part of the ongoing conversation, rather than the final legal outcome. Another key point is the difference between legal certainty and informational completeness. A court may reach a clear and definitive conclusion based on the evidence presented. At the same time, there may still be areas that were never explored within that process. This does not weaken the legal outcome. It reflects the structure of the system, which prioritizes provable claims over comprehensive exploration. Understanding this helps maintain balance. It allows the legal record to be recognized for what it is, a tested and verified set of conclusions, while also acknowledging that it exists within a broader context that may contain unanswered questions. Ultimately, the impact of unasked questions lies in how they shape ongoing interpretation. They remind us that every case has boundaries, and that understanding those boundaries is essential to understanding the case itself. After examining legal relevance, evidentiary rules, strategy, witness limitations, time constraints, privilege, and external factors, a clear conclusion emerges. Some questions remain unasked not by accident, but by design. The legal system is structured to answer specific, provable questions. It is not built to explore every possibility, follow every lead, or satisfy every curiosity. Instead, it operates within a defined framework that prioritizes clarity, fairness, and legal certainty. This framework determines what is asked, and what is not. At the center of this process is selection. Questions must meet multiple criteria. They must be legally relevant. They must be supported by admissible evidence. They must fit within procedural rules. They must serve a strategic purpose. They must be answerable by available witnesses. If any of these conditions are not met, the question may never be asked. This creates a natural boundary. What appears in a trial is not the full set of possible questions, but a filtered subset, carefully chosen to support a structured legal argument. Everything outside that subset remains unasked. These unasked questions fall into different categories. Some are excluded by legal rules. Some are avoided due to strategic decisions. Some cannot be pursued due to lack of evidence or reliable testimony. Others are limited by time, jurisdiction, or confidentiality. Each of these factors contributes to a system that is focused, but not exhaustive. This leads to an important understanding. A trial provides definitive answers to selected questions, not complete answers to all possible questions. This distinction explains why gaps can exist. It also explains why those gaps do not necessarily indicate failure. They reflect the limits and purpose of the legal process. Courts are designed to resolve disputes based on what can be proven, not to explore every unknown. At the same time, these unasked questions still matter. They influence how cases are interpreted, how narratives are formed, and how discussions continue beyond the courtroom. They become part of the broader context, even if they are not part of the legal record. Understanding this dual structure is essential. The legal record defines what has been established. The unasked questions define what remains outside that structure. Together, they form a more complete picture. In conclusion, the presence of unasked questions is not a gap in the system. It is a reflection of how the system works. It shows that the pursuit of legal certainty requires focus, limitation, and structure, even if that means leaving some questions permanently unanswered within the courtroom. And it is within this balance, between what is asked and what is left unasked, that the true nature of the legal process can be understood. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.